Let me tell you something about the Galactic Unified Court of Justice. It's the pride of the Interstellar Alliance, a majestic institution spanning 17 dimensions, where disputes between 37 intelligent species are settled with the utmost dignity and decorum. At least that was true until humans showed up. I'm Clerk Thzzk'tik. That's pronounced with a mandible click after the second Z, but you can call me Tick. I've served as Chief Documentation Officer in the Gukshai for over 300 cycles. In that time, I've witnessed the resolution of the Great Nebula dispute, archived the proceedings of the Hive Mind copyright infringement case, and processed more parking violations on restricted planets than I care to remember. But nothing, and I mean absolutely nothing, prepared us for humans. Humans joined the galactic community only 50 years ago, after their first faster-than-light vessel accidentally crashed into a PRL-Xi'an diplomatic shuttle. Instead of apologizing, the humans invited the ambassador aboard for beer and pizza, and somehow ended up negotiating their planet's entrance into the Interstellar Alliance over what they called happy hour. This should have been our first warning. The Gukshai operates on principles refined over 10,000 years. Our legal system is a masterpiece of logical precision. Every regulation is designed with 16 fail-safes, every statute constructed with quantum linguistic algorithms to prevent misinterpretation. Our judges are a mixture of biological entities, and artificial intelligence matrices have processing capabilities that can analyze 17 billion legal precedents in under a microsecond. And yet humans broke it all in less than a decade. The incident that precipitated the ban on human self-representation occurred during what was supposed to be a routine smuggling case. A human named Madison Cooper was accused of transporting unregistered exotic fruits across the Orion border. The prosecution had overwhelming evidence, scanner records, witness testimonies, and the contraband itself 17 containers of what humans call pineapples. Cooper, declining legal representation, presented her own defense. For 6 hours she argued that pineapples weren't technically fruits but rather collective berries, cited obscure botanical classifications from Earth's scientific archives, to question the definition of exotic in 16 different languages, and somehow managed to convince 3 members of the jury that pineapples possessed sentience and therefore had rights to free movement under Article 7.2.b of the Charter of Sentient Rights. The case ended with 2 judges recusing themselves due to logical distress, 1 jury member attempting to adopt a pineapple, and the head prosecutor taking early retirement to find themselves on a meditation moon. Cooper was acquitted, and pineapples were granted temporary protected status pending a full sentience review. 3 days later, the Galactic Council passed the Human Legal Representation Adjustment Protocol, mandating that all humans must be represented by non-human legal counsel in any court proceedings. The explanation given was to preserve the sanity of the galactic legal system, though officially it was framed as a cultural accommodation measure. I've been assigned to document all human-involved cases since then. They created the position specifically for me after I demonstrated unusual resistance to what's now clinically recognized as human logic exposure syndrome. My species has 3 backup neural pathways, which helps. Which brings me to last week's case. The one that confirmed, beyond any doubt, why humans representing themselves is a threat to galactic jurisprudence itself. Let me tell you about Jack Reynolds and the toaster incident. Jack Reynolds didn't look like a criminal mastermind, standing 5'9" in Earth measurements, with what humans call a dad bod and perpetually disheveled brown hair. He more closely resembled those harmless creatures humans keep as pets, puggles? No, pugs. He had that same bewildered yet oddly confident expression. Reynolds operated a modest import-export business on Outpost Zeta 9, specializing in Earth novelties for curious aliens. His shop, Terran Treasures, sold everything from manual can openers, a bizarre concept to species with suitable appendages, to bubble wrap, inexplicably addictive to many silicon-based lifeforms. His arrest came after a routine customs inspection found 17 devices that triggered every danger sensor in the station. The devices emitted radiation, contained heating elements capable of reaching temperatures that could melt certain species, and most alarmingly ejected objects at high velocity. The customs official, a cautious Ventosian named Drift, immediately classified them as potential weapons and had Reynolds detained under Section 42 of the Dangerous Technology Import Code. The charge: illegal distribution of Class 3 unrestricted weaponry. Now, under normal circumstances, Reynolds would have been assigned a juridical representative, typically a logician from Proxima Centauri, or perhaps a mentamorph from the SETI system. These professionals excel at translating human thinking into comprehensible galactic legal arguments. But Reynolds, in true human fashion, invoked the rarely used Clause 7.b of the Defendants' Rights Act, the right to culturally appropriate self-representation in cases where foreign legal concepts may impede justice. It's a clause originally designed for hive mind species who found individual representation conceptually impossible. The request went before Judge Omura, an ancient crystalline who had been on the bench for over 5 centuries. Against the desperate advice of 3 court administrators and 1 nervous AI legal analyst, she granted the request, citing her interest in observing human legal processes firsthand. That's how I found myself recording the proceedings in courtroom 12J on what would become a legendary day in galactic legal history. The courtroom itself is designed to accommodate all Alliance species, environment-controlled witness boxes, gravity adjustments for different planetary origins, and simultaneous translation into 472 languages, plus 17 telepathic frequencies. The prosecution was led by Prosecutor Vex Alia, a highly regarded axiomatic from the logical quadrant. With 17 tentacles for managing evidence displays and a brain capable of calculating legal probabilities to the 9th decimal place, she had never lost a case. Her assistant, Grix, was a small green mimi-praxian who could recall every legal precedent since the founding of the Alliance. The jury comprised the standard cross-section of galactic citizens, 2 methane breathers in special containment suits, a collective consciousness occupying 3 identical bodies, a time-dilated entity experiencing the trial simultaneously at both its beginning and end, and 8 more conventional life forms of various appearances and cognitive frameworks. As Reynolds entered his plea of not guilty with an asterisk already procedurally irregular, I noticed Judge Omura's crystalline structure flicker briefly with what I recognized as the crystalline equivalent of raising an eyebrow. "An asterisk, Mr. Reynolds?" she asked, her voice resonating through her translucent body. "Yes, Your Honor," Reynolds replied cheerfully. "I'm not guilty, but I'd like to clarify that I did technically do what I'm accused of, just not in the way they think I did." Prosecutor Vex Alia's tentacles rippled in agitation. The defendant admits to the action but disputes the classification. I request an immediate linguistic clarification protocol. Reynolds held up his hand. "No need for that. I'll explain everything when it's my turn. It's really quite simple." Those words, "it's really quite simple," sent a shudder through the courtroom. In my experience, whenever a human says something is simple, galactic legal systems should immediately initiate emergency protocols. And so began the case of Galactic Alliance v. Reynolds, a proceeding that would forever change how the courts dealt with humans and their peculiar form of logic. Prosecutor Vex Alia began her case with the methodical precision for which axiomatics are renowned. Her 17 tentacles arranged holographic evidence displays in a perfect semicircle as she addressed the court. Esteemed members of the jury, Honorable Judge Omura, the case before you today represents a clear and unambiguous violation of Statute 5429B, importation and distribution of unclassified potentially hazardous technology. Her voice modulator projected perfect confidence, each syllable mathematically optimized for persuasive impact. The evidence presentation began with custom scans of the 17 devices. The holograms rotated slowly, revealing metallic objects with internal heating elements, power sources, and what appeared to be launch mechanisms. These devices, continued Vex Alia, 3 of her tentacles highlighting specific components, contain elements that can generate temperatures exceeding 700 Kelvin to produce electromagnetic fields and forcefully eject objects at velocities sufficient to cause injury to 14 recognized sentient species. The jury murmured nervously. One of the methane breathers wobbled in their containment suit, their species equivalent of gasping. Furthermore, Vex Alia continued, the defendant sold these devices without proper safety documentation, usage tutorials, or species compatibility warnings. When the devices were activated in controlled conditions by our security experts, they produced results consistent with Category 3 offensive technology. The courtroom screens displayed footage of a security officer cautiously activating one of the devices. After approximately 90 seconds, the device made a mechanical sound and violently ejected two flat objects, causing the officer to drop the device and trigger containment protocols. Throughout this presentation, I observed Reynolds. Rather than appearing concerned, he seemed to be fighting back a smile. He scribbled occasional notes on an actual paper notebook, a rarity in our digital courtroom, and once or twice actually chuckled audibly, earning him stern looks from Judge Olmora. The prosecution called its first witness, Customs Officer Drift, who floated to the witness stand as Ventosians do, their cloud-like body pulsing with nervous energy. Officer Drift, began Vexalia, please describe the circumstances of the defendant's arrest. I was conducting routine inspections of incoming cargo when my sensors detected unusual energy signatures. Drift's voice whispered like a gentle breeze. Based upon physical examination, I discovered these devices concealed within shipping containers labeled kitchen appliances. And what was your immediate assessment of these devices? They appeared to be weapons of some kind. They contain heating elements capable of causing severe burns, electromagnetic components of unknown purpose, and mechanical systems designed to propel objects at high speed, following protocol. I classified them as potentially harmful technology and detained the defendant. Vexalia then called technical analyst Thzzk'tik, a multi-limbed mycoid with specialized scanning equipment built into their exoskeleton. Thzzk'tik confirmed that the devices contained no safety overrides, no integrated AI limiters, and no species recognition protocols, all standard requirements for potentially dangerous technology in Alliance space. In your expert opinion, asked Vexalia, what is the primary function of these devices? Thzzk'tik's optical sensors whirred as they focused on the evidence. The devices appear designed to superheat organic matter and then forcefully eject it. The purpose could range from defensive to offensive, but the lack of safety features suggests either military application or serious regulatory oversight. Throughout these testimonies, Reynolds's request to cross-examine was denied several times by Judge Olmora, who reminded him that in Galactic Court, cross-examination came after all prosecution witnesses had testified a standard he would have known had he accepted proper legal representation. The prosecution's final witness was Dr. Quiplix, a consumer safety expert from the Regulatory Commission. The small purple being adjusted their spectacles, an affectation they had adopted after studying human culture, and spoke with authority. After thorough analysis, we determined these devices meet 3 of the 5 criteria for classification as restricted technology. They generate heat sufficient to cause tissue damage to most carbon-based species, create electromagnetic fields that can interfere with sensitive biotechnology, and forcefully propel heated objects which could cause injury if directed at vulnerable physiologies. As Dr. Quiplix finished their testimony, the case against Reynolds appeared overwhelming. I noticed several jury members already jotting notes that, from my angle, seemed to indicate their conclusion of guilt. The time-dilated juror, who was experiencing the end of the trial simultaneously with its beginning, wore an expression of utter bewilderment, never a good sign. Vexalia wrapped up the prosecution's case with confident finality. The evidence clearly establishes that the defendant knowingly imported and attempted to distribute dangerous, unclassified technology without proper registration or safety protocols. We ask for a finding of guilt and the maximum penalty of 5 years in a rehabilitation colony plus permanent revocation of trading licenses. Judge Olmora turned her crystalline form toward Reynolds. The defendant may now present his case. Reynolds stood up, stretched casually, and walked to the center of the courtroom with the relaxed demeanor of someone about to explain a simple misunderstanding rather than defend against serious criminal charges. This was the moment the entire courtroom would later reference as when things started getting weird. Thank you, Your Honor. Reynolds began with a smile that could only be described as dangerously cheerful. I'd like to start my defense with a question. Has anyone in this courtroom ever had toast? The silence that followed was punctuated only by the soft whirring of the court recorder that's me and the confused blinking of multiple species' visual organs. Judge Omura's crystalline form flickered with impatience. "Mr. Reynolds, this is a criminal proceeding, not a culinary discussion." "I understand, Your Honor, but this is directly relevant to my defense. You see, these dangerous devices the prosecution is so worried about?" He gestured toward the evidence table. "They're toasters. They make toast. Toast is just heated bread. Bread is a food that humans eat, and sometimes we like it heated and slightly crisped." Prosecutor Vex Ilia's tentacles contorted in what I recognized as the axiomatic expression of skepticism. The defendant is attempting to trivialize serious safety violations with irrelevant cultural context. Reynolds shook his head. "Not at all. I'd like to call my first witness myself and demonstrate exactly what these devices do." After a brief legal discussion, during which Reynolds cited an obscure precedent involving live demonstrations in product liability cases, Judge Omura reluctantly agreed to allow the demonstration under strict safety protocols. Court security brought forward one of the confiscated devices, a chrome-plated rectangle with slots on top along with a sealed container that Reynolds had requested from his ships and stores. "Euphors," with theatrical flair that would have made human trial lawyers proud, Reynolds opened the container to reveal slices of bread. "This," he announced, holding up a slice, "is bread, completely harmless to all known species. In fact, several non-human species in the Alliance enjoy it as an import delicacy." He inserted 2 slices into the slots of the device. "And this is a toaster. Its sole purpose is to heat bread to make it crispy and bring out its flavor." He connected the device to a power source and pressed down a lever. The courtroom collectively held whatever they used for breath. "While we wait approximately 2 minutes, let me address some of the prosecution's claims. Yes, this device generates heat, that's its purpose. Yes, it creates a small electromagnetic field, that's how the heating element works. And yes, when the toast is done, it pops up, that's a convenience feature so humans don't burn their fingers retrieving their toast." As if on cue, the device made a mechanical sound and the bread slices popped up, now browned. Reynolds carefully removed 1 slice and held it up for the court to see. Toast. Not a weapon. A breakfast food. The methane breather jurors bubbled excitedly in their containment suits. The collective consciousness began an animated 3-way discussion with itself. Reynolds wasn't finished. He requested permission to cross-examine the prosecution witnesses, beginning with technical analyst Thzzk'tik. "Analyst Thzzk'tik, before today, had you ever encountered a toaster?" The mechoid's optical sensors whirred. "I had not." "Oh. Is it standard procedure to classify unknown technology as dangerous without researching its purpose in the culture of origin? When a device contains heating elements capable of reaching 700 Kelvin, please answer the question." "No. Standard procedure includes cultural context research." Reynolds nodded. "And did you perform any research into Earth kitchen appliances before classifying my toasters as weapons?" Thzzk'tik's mechanical appendages shifted uncomfortably. "I did not." Reynolds moved on to cross-examine Dr. Thzzk'tik, focusing on the regulatory classification process. "Dr. Thzzk'tik, are you familiar with Section 12 of the Technology Classification Guidelines, which states, and I quote, 'Common household items, food preparation equipment, and culturally significant tools are exempt from Class 3 restriction requirements provided they are properly labeled for their intended use?' The small purple being consulted their documents. "I am familiar with that provision, yes." Reynolds produced a small holopad. "I'd like to enter into evidence the original packaging for these toasters, which clearly shows images of bread going into the device and toast coming out, along with safety instructions in 7 Alliance languages." The courtroom murmured as images of cheerful packaging with obvious bread to toast transformation diagrams appeared on the display screens. "One final question, Doctor. If I were to tell you that billions of these devices exist on Earth in private homes, even in homes with small children, without causing a statistically significant number of injuries, would that affect your safety assessment?" Dr. Thzzk'tik hesitated. It would suggest that humans have adapted to manage the risks associated with the device, yes. As Reynolds concluded his cross-examinations, the atmosphere in the courtroom had shifted dramatically. What had seemed like an open and shut case of dangerous technology smuggling was transforming before our eyes into a cultural misunderstanding of almost comical proportions. But Reynolds wasn't done. In true human fashion, he was just warming up. "Your Honor," Reynolds continued, his confidence visibly growing, "I'd like to address the legal definition of weapon under Alliance Statute 429J. Judge Omura's crystalline form dimmed slightly in what I recognized as the equivalent of a resigned sigh. "Proceed, Mr. Reynolds." "The statute defines a weapon as any device primarily designed or intended to cause harm or injury to sentient beings. The operative word here is primarily. I submit that a toaster's primary purpose is to toast bread, not to cause harm." Reynolds paced the courtroom floor with the ease of someone explaining a simple concept to friends rather than defending himself in an interstellar court. To consider this logical sequence, if we classified items based on their potential to cause harm rather than their intended purpose, we would need to ban nearly all technology. And so, spacecraft engines can cause massive explosions if misused. Data tablets contain components that could theoretically be repurposed as incendiary devices. Even the gravitational adjusters in this very courtroom could, if reprogrammed, crush everyone present. One of the methane breathers wobbled nervously in their containment suit. Furthermore, Reynolds continued, pulling up the Alliance legal code on his datapad, I direct the court's attention to Regulatory Provision 89C7, which states that cultural context must be considered when evaluating the purpose and safety of imported technologies. Earth has been using toasters for over 200 years without classifying them as weapons. Prosecutor Vexalia's tentacles were now moving in patterns that indicated extreme logical distress. Action. The defendant is cherry-picking regulations while ignoring safety compliance standards. On the contrary, Reynolds responded immediately, I'm about to address compliance directly. He tapped his datapad again, bringing up a new document. Alliance Import Directive 42B provides a simplified compliance pathway for culturally significant items of daily use from newly admitted member species. Earth joined the Alliance only 50 years ago, which means we're still in the cultural integration period. Under this directive, I was required only to provide proper labeling and usage instructions, which I did. He displayed the toaster packaging again, now highlighting the safety instructions printed in multiple languages. Judge Omura interrupted, her crystalline structure vibrating at a frequency that indicated deep thought. Mr. Reynolds, are you suggesting that all 17 devices seized were exempt from standard safety protocols due to this cultural integration provision? Exactly, Your Honor. And I'd like to point out that I've filled out Form 62T for traditional technology integration for every shipment of Earth appliances I've imported. I have copies here, all stamped and approved by Alliance Customs. Reynolds presented a stack of documentation that, I noted with professional interest, was indeed properly filed and stamped. As a court clerk, I found myself reluctantly impressed by his paperwork management. The courtroom atmosphere had shifted dramatically. 2 jury members were now examining the toaster with curious appendages. The collective consciousness had entered what appeared to be a heated debate with itself, all 3 bodies gesticulating in different directions. Sensing his advantage, Reynolds delivered his masterstroke. Your Honor, I move to dismiss all charges based on precedent case Sorblat v. Ace, the Alliance, in which the High Court ruled that prosecution for cultural misunderstandings without malicious intent constitutes procedural overreach when alternative regulatory remedies exist. There was a moment of silence as Judge Omura accessed the case reference. Her crystalline form briefly glowed brighter, the equivalent of raised eyebrows. The defendant's citation is accurate, she admitted. Prosecutor Vexalia was not ready to concede. Even if we accept the cultural context argument, the defendant failed to provide proper usage demonstrations at the point of sale, which is required even for culturally protected items. Reynolds smiled. Actually, I did. I'd been including instructional holo pamphlets with every purchase. And he paused dramatically. "I've been offering complimentary bread with every toaster sold." He activated a small holographic projector that displayed his shop. The recording showed Reynolds cheerfully demonstrating a toaster to a group of fascinated aliens, complete with free bread samples. One of the methane breathers in the jury made a sound that the translation system rendered as OWBU. Judge Omura's patience was clearly wearing thin. "Mr. Reynolds, while your defense has raised several valid points regarding cultural context and regulatory compliance, you still imported heating devices without standard Alliance safety features such as sentient recognition shutdown systems and anti-misuse protocols." Reynolds nodded thoughtfully. "That's a fair point, Your Honor. But consider this. Alliance safety standards were developed for species with vastly different physiologies and technologies. Earth appliances are designed with human safety considerations in mind. Adding Alliance standard safety features would actually make these devices more dangerous to humans." "Explain," demanded Judge Omura. "Gladly. Standard Alliance safety protocols include telepathic user interfaces and quantum state recognition systems, technologies that can cause neurological disruption in humans. We're one of the few species that can't process telepathic signals properly. It would be like requiring breathing apparatus that works for methane breathers to be installed in oxygen environments fundamentally incompatible and potentially harmful." The legal logic was twisting into knots that even Judge Omura's crystalline computational mind seemed to struggle with. "I noticed her structure vibrating at frequencies typically associated with processing conflicts. Additionally, Reynolds continued, seemingly oblivious to the judge's growing discomfort, under Section 498.3 of the Cultural Exchange Protocols, there's a specific exemption for technologies that have existed on a member world for more than 100 local years prior to Alliance admission. Toasters have existed on Earth since the late 19th century, approximately 200 years ago. This makes them exempt from retroactive safety modifications under the Historical Technology Preservation Clause." The time-dilated juror, who was experiencing past and future simultaneously, suddenly emitted the equivalent of a laugh, a disturbing sound that resembled glass breaking in reverse. The prosecutor Vex Alien made one final attempt. "The defendant's arguments, while creative, ignore the fundamental Alliance principle that safety standards supersede cultural considerations when potential harm exists." Reynolds nodded respectfully. "I completely agree with that principle. But the prosecution has failed to demonstrate actual harm rather than theoretical harm. In over 2 centuries of toaster use on Earth, with billions of units in operation, toaster-related injuries represent less than 0.0001% of household accidents. By comparison, CEC, the Standard Alliance Food Preparation Unit, has an accident rate of 0.00003%, making toasters actually safer than the approved alternative." As he presented these statistics, complete with comparative safety charts, I could see the exact moment when the case collapsed. Judge Omura's crystalline form dimmed to a frequency I had only seen once before during the infamous "Is a self-aware sandwich legally alive?" case of the previous decade. The human had done it, using nothing but precisely cited regulations, cultural exemptions, and statistical evidence. He had transformed a serious criminal case into an absurdist lesson in cross-cultural understanding. And the worst part, he was legally correct on every point. Judge Omura's verdict came after only 15 minutes of deliberation, a record in Galactic Court, where decisions typically take days or even weeks. This court finds the defendant, Jack Reynolds, not guilty of illegal technology distribution. The toasters in question are hereby reclassified as cultural food preparation devices and exempted from Standard Alliance safety protocols under the Historical Technology Preservation Clause. She paused, her crystalline structure vibrating at a frequency that I recognized as the crystalline equivalent of a headache. However, she continued, "The court mandates that all future imports of these devices must include clear warning labels stating, 'This is a toaster. It makes toast from bread. It is hot when operating. Do not insert non-bread items. Not a weapon,' in all Standard Alliance languages." Reynolds nodded respectfully. "I would be happy to comply, Your Honor." Furthermore, Judge Omura added, The defendant is ordered to conduct 3 public demonstrations of proper toaster usage at the Galactic Cultural Exchange Center to prevent similar misunderstandings in the future. As the courtroom began to clear, I observed several jurors approaching Reynolds with questions about toast and whether other human foods underwent similar transformative processes. The collective consciousness seemed particularly intrigued, all 3 bodies simultaneously pantomiming the act of pushing down a toaster lever. The case immediately generated shockwaves through the galactic legal system. Within 3 days, an emergency session of the Judicial Council was convened to address what was now being called the Reynolds precedent. The concern was legitimate. If a human could successfully argue that a heat-generating, object-ejecting device was exempt from safety regulations based on cultural traditions and historical usage, what other dangerous technology might be justified through similar reasoning? The result was the most specific piece of legislation ever added to the Alliance legal code, the Human Legal Representation Adjustment Act, commonly known as the Toaster Law. This comprehensive regulation mandated that all humans must be represented by non-human legal counsel in any court proceedings, with a footnote specifically mentioning toasters as the precipitating incident. The official rationale provided was to ensure proper cross-cultural legal translation and prevent misunderstandings arising from unique human logical frameworks. Unofficially, as Judge Omura later confided to me during document filing, it was to protect the sanity of the galactic legal system from human reasoning. More amusing still was the fate of Jack Reynolds. Far from being deterred by his legal adventure, he leveraged his newfound reputation to establish Reynolds Cultural Legal Consulting, a firm specializing in helping aliens understand human products and humans understand alien regulations. His services became so sought after that he now commands consultation fees higher than most top-tier juridical representatives. His toaster demonstration at the Cultural Exchange Center drew record attendance, with beings from across the galaxy gathering to watch bread transform into toast. The event spawned a surprising trend. Toast became a fashionable delicacy in upscale alien establishments, with authentic Earth toasting methods advertised as a luxury experience. As for me, Clerk Thzzk'tik, I received a commendation for maintaining perfect records throughout what is now used as a case study in legal reasoning stress management for court officials. My detailed transcript of Reynolds' defense is required reading at the Galactic Juridical Academy, typically accompanied by stress reduction exercises and philosophical counseling. The greatest irony. 6 months after the trial, the Alliance Safety Commission completed a comprehensive study of human household appliances and concluded that toasters were indeed remarkably safe for devices that generate such high temperatures. They remain the only Earth technology granted a blanket exemption from standard safety protocols. Yesterday I received a package in my office, a brand new toaster from Reynolds' shop, complete with a loaf of what humans call sourdough bread and a note that read, "For your breakfast enjoyment. Warning, makes toast, not trouble." I've already used it 3 times. The toast is, I must admit, delicious, especially with Centaurian honey. Just don't tell the Judiciary Council I have it. After all, some cultural exchanges are worth bending the rules for, even for a dedicated court clerk like me. And that, my friends, is why humans are no longer allowed to represent themselves in galactic court. Though between you and me, I suspect it's only a matter of time before they find a loophole in that regulation too.